This is Paul Turner, the Immigration Barrister at Imperium Chambers. Please subscribe to my channel if you want to be up to date with all immigration news. More news on the Priti Patel's plans to remove asylum seekers to Rwanda and what applicants can do. In this video, I'm going to explain how to respond to the Rwanda removal notices that have been sent out. Following the Migration and Economic Development Partnership between Rwanda and the United Kingdom, which was announced last month, some people might say it was a bribe of 120 million, the Home Office wishes to begin removing asylum seekers to Rwanda from the 14th of June 2022, so not very long away. It is vital that if you receive such a notice, that you get in touch with a reputable immigration lawyer as soon as possible. And in this regard, I am more than happy to help anybody that receives such a notice. The purpose of this video is to give applicants and indeed representatives a better understanding of how to respond to notices in relation to the proposed removal to Rwanda, what can be done basically. It should be noted at the outset that these are not decisions or removal directions. Generally, if the person is served with a notice in detention, they are told to respond within 7 days. However, if they are not in detention, the Home Office will give them 14 days to respond to such a notice. The notice will be accompanied by a leaflet that should state an email address to which any representations or other correspondence should be sent. So it's vital that this document and email address is considered and remembered. The people that are unable to find a legal representative before the expiry of the deadline for responding to the notice should not be unduly worried, as they will have the option to request an extension of time in order to put forward representations. If somebody can't write an email, unusually, given Section 84 of the Immigration and Asylum Act 1999, a non-lawyer could be asked to write it for them without breaching the law restricting who can provide immigration advice and representation. An extension of 7 days is being granted without any difficulty. Therefore, if you have any exceptional grounds, a further extension may also be granted. So you will have time if you get in touch with a lawyer or you contact a lawyer to put forward representations. If you have to, do it yourself, but it's never my advice for individuals to deal with the Home Office directly, because the Home Office are quite tricky, to say the least. Despite the Home Office's attempts, there are a number of steps which the Home Office will need to carry out to lawfully remove a person to Rwanda. I'm going to set out the steps, and they are as follows. Firstly, the Home Office has to carry out an adequate investigation into the person's basis of claim and individual circumstances. Then there has to be a decision made on whether the asylum claim is inadmissible. Then the Secretary of State will have to certify the asylum claim under paragraph 17, Schedule 3 of the Asylum and Immigration Treatment of Claimants Act 2004 on the basis that Rwanda is a safe third country. Fourthly, they will then have to go on to consider the human rights claim and certify any human rights claim, i.e. on the basis that removal to Rwanda will not breach their human rights or that an appeal can be carried out from out of country. Every asylum seeker should be given a leaflet which states that a total of 5 working days should be given prior to the date of removal. So you'll have 5 days even if you submit the representations. The department's policy on what amounts to inadmissibility and why they can send people to Rwanda is that it basically falls back onto the safe third country principle, which states that any judicial proceedings challenging asylum inadmissibility, including unfounded, are likely to have suspensive effect, which means that individuals must not be removed from the United Kingdom until the proceedings have concluded. In a case where the removal is by charter flight, it may be necessary to apply for a court injunction to stop the removal, as judicial review on its own will be non-suspensive. And in my view, it's likely that the Home Office will employ charter flights to Rwanda. Now, the next step is once the removal notice has been received, responding to the notice will likely involve certain steps which are as follows. It will be necessary to take detailed instructions either from the individual or from the client, addressing why the client didn't apply for asylum or protection in a country they passed through, whether they have a history of trauma, mental illness or other vulnerability, and whether they have connections to the United Kingdom. In cases where there is vulnerability and the client has not been assessed by an immigration removal centre doctor, it is vital that they are assessed first before they are proposally removed to Rwanda. The Home Office must request relevant documentation, consider whether there are any other medical or expert evidences required. This is important, especially if someone suffers from mental problems or has some other issues. Carry out country of information research, both in relation to the country of origin and Rwanda, and set out the difficulties either in the country of origin and or Rwanda. Then submit a request if they're detained to the Home Office for immigration bail for yourself or for your client if you're a representative. In order to respond effectively to the notice of removal, it is fundamental that the following steps are carried out. If they're not carried out, then people could be removed where they need not be removed. It is essential to assess whether you're submitting representations or there are any other matters that you wish to challenge in any future judicial review proceedings. You've got to set your case out as early and as comprehensively as possible. Set out the limitations that you are able to make in the timescale allowed. So explain if you have difficulties and you need more time. If you have a human rights claim, raise the human rights claim as soon as possible and put in as much detail as you can about it. Address the Home Office's own asylum inadmissibility criteria to try and identify or explain why the case is not an inadmissible case. And then in the representations, raise any potential judicial review grounds that the Rwanda policy itself and the process of selection for people is unlawful. It must be done before any judicial review claim is lodged. Although the notice itself is not a decision, set out why any decision to decide that the client's case is inadmissible and seek to remove them to Rwanda is unlawful. Again, it's setting stuff out as soon as information and providing it to the Home Office at the earliest available opportunity and not at a last-minute judicial review. Any unlawful detention argument should also be raised, again, at the earliest available opportunity. And most importantly, request any and all documents, such as communications between the Rwandan authorities and around the selection criteria. It is better to be as well informed about this situation as you can. If any legal representatives carry out these steps that I've amplified in this video, there's a fair chance that the removal directions for the asylum seekers may not actually take place. So again, if you receive such a notice that the Home Office does intend or wish to remove you or one of your clients to Rwanda, there are steps that you can take and ought to take, and you ought to take them at the earliest available opportunity. The reason for this, as I've mentioned, is that raising them for the first time in a judicial review is not good practice, and the court are likely to reject it on the basis that you could have said it earlier. And indeed, there is no real good reason why you cannot say it earlier. Indeed, the moment anyone receives such a notice, they ought to get in touch with a reputable lawyer. Get in touch with me if you want to, and I'll do my level best to help you. Thank you very much for watching this video. It follows on from my previous video relating to the Rwanda flights, and I hope it's been of some use. As I say, if you do have an immigration problem or a concern, whether it's regarding Rwanda or another country, then get in touch with me. Thank you very much for watching. This is Paul Turner, the immigration barrister at Imperium Chambers.